Raj, Kanda, welcome to the library. Thanks for joining me today. Tell me what you do for a living.
So I'm a barrister based out of Linenhall Chambers in Chester. I specialise only in family law. So in particular, I focus on child arrangements and finances on divorce, but I also have a lot of experience and do a lot of work involving domestic abuse.
Wow, okay. So Raj, in your job, in your daily job, what are your main tasks?
Predominantly, I'm in court most days, dealing with either initial applications for child arrangements orders, urgent injunctions, or dealing with applications for financial relief in the context of divorce.
And so just so our listeners are clear, what's the difference between yourself as a barrister and a solicitor?
That's a question a lot of people ask, and it's not easy to draw a distinction if you don't really understand how the two jobs work, if I can put it that way, because they are two entirely separate jobs altogether. I suppose the best way of looking at it is like this: a solicitor will do the face-to-face to begin with. They will do all the preparation, and then they will come to me and other barristers, of course, for specialist advice, but more often than not, representation in court, and that's where we step in.
So your job is advocacy, isn't it? Speaking on behalf of your client, putting their case across.
Predominantly, yes.
Yes. And so if a person wanted to come and instruct you, how would they do that?
Well, there are two main ways of doing it. You could either go through your solicitor, but that will incur more costs, because not only are you paying your solicitor for their advice, but then on top of that you'll be paying me for whether it's a fee for advising in conference, or to attend court, or even to provide a written advice. Or you've also got the option of instructing me directly, and depending on the case, that might work better for some clients than for others.
So if a person, a client, wanted to come along and instruct you as a direct access, would they contact yourself, or do you have a chambers?
So the vast majority of barristers will operate out of chambers. So as you know, I'm based out of Linenhall Chambers in Chester, but just because that's where I'm based, it doesn't mean that I'm restricted to the area. I travel all over the country. But yes, you would contact chambers, you would speak to a member of the support team, and they would obviously ask questions as to what the nature of the inquiry is. Then they would arrange a free consultation with me. I would ask more questions, and then very quickly we'd be able to get things moving.
And what sort of work can you conduct for a direct access client? Can they have your opinion, or do you just go to court?
No, it can be a wide range of things. So I do a lot of direct access work. Sometimes clients will get in contact with me just to provide initial advice and almost give them some kind of roadmap as to how they should be looking to approach a case that they're going to litigate on their own. Or they may instruct me to do individual hearings. A lot of clients will instruct me to provide them with a written advice.
Right.
It really does vary. But again, it's not for everyone, because it does involve doing a lot of the admin yourself, so paperwork. You also lack the benefit, I would say, to some people of having someone at the other end of the phone all the time, because that's the benefit of a solicitor. You can ring someone up quite regularly, whereas with me, it's almost like it's a pay-as-you-go service.
Right, I see.
And that's how all direct access barristers will operate.
your clients give you a task, you complete it, and then you don't give ongoing support in between the tasks.
It's designed to be of benefit to the client because we operate on a fixed fee basis. So you agree upon the service to be provided, you agree upon the fee, service is delivered, and that ends that particular transaction. Yes, of course, there's a degree of latitude either way. So of course, I will respond to emails and calls in relation to whatever it is that I've been asked to do. But beyond that, then the agreement ends there. But that's the benefit to it, because clients then know they can budget, they know what they're getting, and they can move on to the next stage.
Sounds a really good service to me. If we segregate the family matters for a moment and we talk about child arrangements,
yes.
What are the most common mistakes you see in the family court by your clients? So people who have instructed you and obviously have got to the stage of court. If you could give them early advice, what would it be?
That's a really interesting question, because I'd say most of the time when I see two parents at war with each other, because that's often what it amounts to, more often than not, whilst parents will say they're here for the children, and they are, they focus, quite understandably I would say, on the dispute between them as parents, rather than actually what is going to be in the best interests of a child or their children. It's often focused on what's happened in the past, rather than looking forwards. And I know how difficult that must be, but that is often one of the biggest stumbling blocks to two parents reaching an agreement in relation to children.
There's a lot of criticism at the moment about child maintenance and the service that's provided by the government for child maintenance. How do you see the effects of the child maintenance system on litigation? Do you see it playing through?
Yeah, it does, because even though as barristers we don't, well, in the context of child arrangements and finances, on divorce, we don't deal with child maintenance. But what often happens is, if one party perceives the other to either not be pulling their weight, if I can put it that way, in relation to child maintenance, that is often then conflated with issues in relation to how child arrangement should look. So for example, well, if he or she isn't going to pay the maintenance, then they shouldn't be having contact. But that's not how it works.
No.
So that is a regular stumbling block that I will come across.
One of the biggest questions on our Facebook page is, does a party want 50-50 contact arrangements just to avoid child maintenance?
Yeah.
Do you hear that a lot?
I hear that all the time.
Right.
I hear that all the time. And I can say it is. I can say quite confidently, it is not an argument that any judge is going to be persuaded by when they are being asked to consider whether a shared living arrangement, as you put it, 50-50, and I'll come on to that in a moment. When they're being asked to consider if a shared living arrangement is in the best interests of a child, and again we hear this phrase 50-50 all of the time. And again, I see it from a parent's point of view. When they say 50-50, in a lot of parents' minds, that should equate to an equal division of time. But 50-50, and the case law tells us this, does not necessarily mean an exact and equal division of time. It is a label. It's just a label that sets out that a child or their children are living with both of the parents. And quite often, and again, I really do understand it, the label of an arrangement often seems to cloud the judgment of parents rather than thinking about what the day-to-day reality and practicalities of whatever arrangement it is that they're looking to implement.
Yeah. One of the issues I hear our listeners talking about is the length of time it takes to ask the court for help and get that help. Do you know how long on average a child arrangements case will last?
There isn't an easy answer to that.
No.
I have been involved in cases that have lasted, in the context of private law children cases, that have lasted 3 or 4 years.
Wow.
I mean, that is an extreme example where there are some that only last around 6 months.
Great.
Which is what every parent would hope for. But the difficulty that we're up against is this. There are year on year an increasing number of applications which are being made. The courts are incredibly busy, overrun with work.
Right.
Not just children work, but financial remedy work as well. There's also a lot more insofar as domestic abuse is concerned. So we're talking about injunctions and things like that. So the difficulty is capacity.
Right.
And the number of judges that are available to deal with those cases. So it's not quite as severe as what the criminal courts are having to deal with, because you don't have to look too deeply into the press to see that some criminal cases are taking years. Thankfully, we're not there yet, but the delay is a massive issue.
What other options have parents got, still sticking with child arrangements, what other options have they got if they want to get a solution to an ongoing argument, battle, disagreement?
Yeah. Look, I mean, it's again, that's a really difficult question, because if two parents or parties or whatever the situation might be, if they were able to come to an agreement that works for their children or works for them as parents, then the chances are they wouldn't then be in a position where they're even contemplating litigation. That's the difficulty, isn't it? So if they're at the point where proceedings are being issued, they're almost saying to a court, look, we've taken it as far as we can. We're putting this now into the hands of a stranger. And that means potentially leaving with an outcome that neither of them are happy with.
Yes.
So if it is possible to put differences to one side, as difficult as that might be, I always say, you're more likely to make a plan work if you agree to it yourself. It may not be something that you want, but it's something you can live with. So I always encourage my clients, in the context of litigation, to try and reframe how they may look at something, and then just try to find a way forward to avoid a situation where a judge is having to make a decision for their children.
And if somebody at the moment is contemplating applying to court, what would you say to them?
I would urge them to reflect on what they are actually hoping to achieve.
Right.
If what they're hoping to achieve is a defined order, a clear pathway as to how their child is to spend time with them or the other parent, rather than focusing on what may or may not have happened in the past, try to look forward.
Right, try to look forward.
Try to look forward and try to work out what is actually going to be best for you as a family in this new normal. I should say one significant caveat to that: if domestic abuse is being raised as a barrier to any contact, well, that's a very separate issue altogether.
Got you.
That's a very separate issue. But if that isn't being raised as a prohibition, if I can put it that way, to any contact taking place, then whilst it's challenging, I accept that. It's about looking as to what they think is going to be an acceptable solution, and if they can address their minds that early on, the chances are they can reduce the length of those proceedings.
A difficult question for you, and I understand if it's not one you can answer. There's a lot of allegations, of false allegations of domestic abuse in the family court, isn't there? How do you see judges managing whether an allegation might be true or might be false?
Well, it's an impossible position for any judge to be in, and the only way of determining whether an allegation has been made, well, the only way of finding out whether an allegation is false or not is by listening to evidence.
Right.
You know, we are not, as lawyers, judges, we're not concerned about what people think as much, but the concern is what can people prove.
Right.
So, and that's where evidence really comes to the fore. So that is the only way in which any judge is going to make a determination. They're going to listen to the evidence and make a decision. But you know, people do have to think really carefully as to whether that is a process they want to go through, because a finding of fact hearing, which is effectively a trial, it's a bruising experience, and things get said which can't be unsaid. Nobody can predict the outcome of a hearing of that nature, because evidence has a real funny way of creeping up on people. And it's something that everyone should think really carefully about before they go down that road.
So what would you say to somebody that's currently accused of a domestic violence incident that they say the allegation is false?
Look, I'm concerned primarily with one thing in that scenario, and that is evidence. What does the evidence tell me? That's what people are paying for when they come to a legal professional, for us to assess, to analyse and to advise. And as I often say, a lot of the time I have to give advice that people don't want to hear. Right. And it's in those situations where people have to think very carefully as to what the next step will be. But if someone hasn't done something, then they should maintain that stance. They shouldn't just accept they've done something for an easy ride, if I can put it that way.
Right.
If an allegation is false, then it must be resisted. But if it's true, then it would be ill-advised to say otherwise.
Right.
Because that will not reflect well on that person ultimately at the end of the process.
I think that's very clear advice. If we talk about financial remedy in the court arena, what are the main mistakes you see that parties make in the family court financial?
Time and time again, trying to hide assets.
Gosh.
Okay. Full and frank disclosure is it's imperative. There's just no excuse to try and hide assets, because it will end generally not very well.
Right. So parties on their declarations, and so on their Form E, and then in their further disclosures, etc., they don't declare things or they minimise things. It causes what happens?
Well, firstly, it will increase the length of litigation.
Right, which is expensive.
Which is really expensive. It also just then eats away at the pot of money that's available. And that's something which sometimes, understandably, a lot of people don't see, because by the time they're engaged in financial remedy proceedings, any prospect of cooperation has long since dissipated. And the longer the fight goes on, the less there is available at the end of the road. Okay?
That's for both parties.
Exactly. It's for both, because the costs can be astronomical. And some people wrongly assume, well, if I prove X to be right or X to be wrong, I'm going to get my costs back. It doesn't work that way.
Really?
It's a really high threshold for a judge to make a costs order within family proceedings.
Is that something that I think litigants in person and people setting out in the process before they hire a lawyer are threatened with quite a lot? We'll ask for costs against you, and you're saying that it's quite irregular.
I think it's quite rare to get an adverse costs order. Conduct has to be really quite severe.
Wow.
Before a judge will make a costs order. But every case is going to be judged on its own facts, and there is a range of there is a wide discretion available to all judges as to when they think it is just, necessary and proportionate to make an adverse costs order against any one party. The key to it is just be straight, be honest, and you're going to reduce the possibility of being at the thick end of an adverse costs order. But it's things like failing to disclose information, failing to engage with the process, conducting yourself in a way that inevitably causes the litigation to become more and more protracted. Those are the types of things which are going to put you in the danger zone of being subjected to an adverse costs order.
Wow. What other punishments, if you like, or penalties are there that you've seen a judge use to punish, I suppose, somebody that hasn't been honest?
Well, they can, if someone hasn't been honest or continues in their attempt to withhold documents which a judge may think, had they been available, could have actually been of relevance, then they can give one party the benefit of any doubt and award them more, for example.
Wow.
There are things where money has been dissipated, if you like, or assets have been squirreled away, or they're no longer available, then judges can add back, which means they're effectively saying, well, that's gone now, but I'm going to add it back in, thereby giving the other party more of what's available in the pot.
So somebody spent a lot of money, as you know, during the separation process in order to get rid of things, so that the other party can't have their share. The judge might add that back.
Well, it's conduct. That's bad conduct, and that's something which could lead to a costs order.
Wow.
But conduct has to be serious.
Yes.
And that's a conversation for another day. But it's always something which is raised with me. But it's not that easy to prove that someone's behaved so badly that there should be, they should be penalised to the extent where they pay costs or the other party is given more. The starting point has to be transparency and honesty, and coming to the table with a realistic solution based upon what their needs are, but not just their needs. You've got to consider what the needs are of the other party as well.
Right.
You've got to come into this with open eyes in that sense.
That's really interesting. You talk about needs. So how does a judge make a decision? Does he just look at needs of the parties?
Most cases that I deal with are based on needs, and it's the needs of both.
Right.
Okay. So more often than not, the cases that I deal with, one party has a greater need than the other.
Okay.
Okay. but it's how we go about establishing that. So one party might assert to have an inferior earning capacity to the other. Well, that's all very well saying that, but you've got to be able to prove it.
Right.
Okay, so you might be able to prove it by getting, say, a report from an occupational therapist. You might be able to prove it by the fact that you are of a certain age, and it means now you've got less chance of being able to requalify and improve your earning capacity. You may have less earning capacity because you're the party that that has been the stay-at-home parent for 25, 30 years, whereas the other person has been at work. So that reduces your earning capacity. There's lots of ways to demonstrate that particular aspect of need.
So the way I understand it, and you have to correct me if I'm wrong, there are three main needs. Is that right?
Well, so you've got housing.
Housing, yeah. Pension, retirement in the future.
Yeah.
And income.
Yeah.
Right, and those are the three things that the judge looks at. Is that correct?
Well, broad. I mean, not every case has a pension feature.
Right.
Okay, because a lot of people don't have pensions, but housing needs is often top of the list.
Right.
Because in most cases, there is just the one property, the former family home. If we assume there is a decent amount of equity in that property, then the question for any judges is, well, does the house need to be sold? And if it does need to be sold, who's going to get the lion's share? And that comes down to, well, which party is the greater need? And that is often what causes the most disagreement in that scenario.
Right. Do most parties that come to you want a 50-50 split of all their assets, or do most parties, do they seek a departure from equality?
Most seek a departure. I think I'd say 95% of the cases I deal with, there is always one party saying that their needs are greater than the other.
And the result in the court, is it more likely that there will be a need that's greater than the other?
Generally, especially if there are children involved, but people need to be realistic as to what that departure from equality is going to look like. So coming to court and saying, well, I think there should be a departure of equality to the tune of 90% in my favour, in most cases is unrealistic. So again, it's important to be realistic as to what you're likely to achieve. But again, that is why you come and seek independent advice. And again, it's a bit like with the approach I would take to child arrangements orders. You need to aim, I would say, to leave with an outcome that is acceptable and one that you can live with, because very rarely does anyone leave with what they want, because what people want is often unrealistic. Right.
So how does somebody understand what they're, I hate to say it, but entitled to? How does somebody actually learn what they should be asking for?
Well, that is why they seek advice, because it's almost impossible to know what they're asking for, because let's remember, nobody goes into marriage on the understanding that in a number of years' time they're going to have to then understand what it is they're entitled to at the end of it. That's not how, quite rightly, that isn't the approach. But the longer a marriage goes on, the more likely it is that a judge is going to find that the assets are part of the marriage. Okay?
Right.
So, in which case, everything goes into the pot for consideration.
Yes.
In certain circumstances, yes, there are things which may be outside of the pot and don't fall to be considered, but that is very much fact specific, and is not a one size fits all solution at all.
And a solicitor or barrister would be able to advise on whether there's things outside of the pot or...
Absolutely.
Right.
Absolutely, yes. And that's why I think it's really important to go and seek that advice, because you do need clarity. Because once that order is made final, once you get a clean break, that's the end of it. So getting advice early on, even if you then choose to represent yourself later on down the line, that's fine. But getting some kind of roadmap, some kind of direction sooner than later is what is really going to help. I have clients which I represent now who have come to me later in the process, and it ends up costing them more in many ways, because A, they're having to pay me to effectively trawl back through evidence and previous court documents. They're then being presented with an opportunity to settle, but because they've come so far, they've incurred more costs, arguably, and there's less in the pot because for whatever reason things have taken longer to resolve.
Yes.
So the sooner you seek advice, whether it's from someone like me, you, a solicitor, the better the chance of you being able to reach an outcome that is acceptable to you. Obviously that does not account for the other side. And
No.
if the other side aren't going to play ball, then it restricts your ability to drive things forward and find a solution.
If you were going to give one piece of advice to our listeners that would be key, let's say, for example, they're heading into financial remedy proceedings, they feel they've got no option to head into proceedings, what's the one piece of advice?
Try and work out in your own mind what it is you can live with.
Right.
Try and work out your best case scenario, worst case, realistic. That's how I approach it.
Okay.
When I'm doing my preparation, I have 3 scenarios that I think, based on my assessment of the evidence, would be likely in that case at that particular time. Of course, that's fluid because it changes as the evidence develops, and at every stage I'll always reassess that. I would say, if you're able to, work that out based on the information you've got, best, realistic, worst case scenarios, and then at least then you've got a benchmark as to what you are aiming for. Because remember, one day all of this will be over. It's hard to see, but I say this to my clients all the time, it will be over one day. What do you need to leave with now that's going to allow you to move on onto that next stage of your life? And I often find that helps people. I think it brings people comfort, but it also brings them clarity and focus.
Yeah, I understand. Because the process, wherever the parties are in the process, it's incredibly inhibiting, isn't it? Emotionally draining.
It's dreadful. It's absolutely dreadful. And I think what sometimes people forget is they just see the suit.
Right.
Yeah, and they don't see there's a life behind the suit. So I don't mind saying I've been through it, and my priority was I just want to get this resolved as quickly as possible. And it's dreadful, even with the knowledge that I have. But I did. I resolved it with my now ex-wife, and it's all dealt with. And that doesn't happen to everyone.
No.
But I now have an even greater insight into the benefits of trying to resolve things quickly, but also realistically. I.e., you may not leave with everything that you think you are entitled to or that you want, but the peace of mind that you get by being able to resolve things sooner than later is perhaps worth a lot more.
Right. So should people continue to negotiate even if they feel they've got no option but to go to court, or even if they are in court, can they still negotiate?
Well, yeah. I mean, it's always open to put forward realistic and reasonable offers to the other side. Always. I think if people can have very much at the forefront of their mind that the objective isn't to necessarily leave with what they want, but what they can live with, because what they leave with now, well, in 5 years' time, life will have moved on. And whilst that might be difficult to envisage at this point in time, when everything is raw and real, and whilst endpoint might not be something they can see, I can see that for them. So the difference between getting, I'm going to pluck a figure out of the air, 150,000 and 170,000 may seem like a gulf that they can't contemplate. But in several years to come, this will be old news. And they'll have to ask themselves the question, was it worth the fight? Or was it actually better for their own peace of mind, for their own sanity, if you like, just to say, okay, I'm going to compromise on that and walk away with that now, because it means it's done.
Compromise is the key, I guess.
Well, compromise is the key, because as well, if I use that figure again, the difference between 150 and 170 is, well, you could end up spending another £10,000 in cost in trying to achieve your 170.
Right.
Well, was it worth it? Was it worth the mental anguish? Was it worth the extra legal costs to achieve that? I'd say probably not.
Right.
It's probably not. So there's a lot you've got to consider before you make a decision to fight to the end.
Right.
Okay. And these are the conversations I can have on a one-to-one basis, whilst applying the particular facts of the case.
I think you've been an incredible guest in the library. I've learned so much myself today, and I really hope everybody listening has got what they needed from it too.
Good.
You're found in Lillenhall Chambers.
Lillenhall Chambers in Chester, yes.
Fantastic. Yes. And you work all over the United Kingdom. My goodness,
Yes.
do a lot of driving.
I do.
And thanks for coming in, and you've been amazing.
Thank you very much. Thank you for having me. Thank you.